Sandy and Casey Parsons. For nearly 2 years, Erica Parsons was not on any missing persons list. Her school did not know she was gone because she had been pulled out years earlier and homeschooled under her adoptive parents' own paperwork. Everyone in Rowan County, North Carolina, believed she was simply living with a grandmother somewhere in the mountains near Asheville. But the grandmother did not exist. She had never existed, and the people who invented her would continue collecting adoption assistance checks for a child they had already buried in a shallow grave across the state line. Erica had been placed with Sandy and Casey Parsons as an infant. Her biological mother, Carolyn, felt unable to raise her and entrusted her to relatives who eventually adopted her. Erica had hearing loss and speech delays that were only diagnosed during the brief period she attended public school. To the outside world, the Parsons were an ordinary large family living on Miller Chapel Road, raising 5 biological children alongside their adopted daughter. Around 2008, Erica was withdrawn from public school and enrolled in what state records listed as Parsons Christian School, an in-home program run by the family itself. That single administrative decision cut her off from teachers, counselors, and the routine of mandated reporters who might have noticed something was wrong. Relatives would later describe a household in which Erica was not treated the same as the family's biological children. She was last seen in late 2011. She was not reported missing until July 30th, 2013. And that report did not come from her adoptive parents. It came from their biological son, Jamie Parsons, who walked into the Rowan County Sheriff's Office after an argument that ended with his parents throwing him out of the house. When investigators asked Sandy and Casey where Erica had gone, they gave the same story they had been telling relatives for nearly 2 years. Erica had gone to live with her biological grandmother, a woman they called Nan, in Asheville. Investigators searched for Nan. The FBI searched for Nan. Even a private team working with the Dr. Phil program searched for Nan. She could not be found because she had never existed. Relatives on Erica's biological side confirmed there was no such person in the family. For years, the case sat without a body. That changed in 2016 when Sandy Parsons, then serving a federal sentence for defrauding the government by continuing to collect adoption subsidies in Erica's name, led investigators across the state line into Chesterfield County, South Carolina. In a wooded area off Blair Hendricks Road, he pointed to the spot where he said he and Casey had buried Erica in December 2011. The autopsy that followed listed her passing as a homicide by violence of undetermined means. The medical examiner could not identify a specific mechanism, only that her passing was not natural, not accidental, and not self-inflicted. How does a child disappear for nearly 2 years without a school, a doctor, a neighbor, or a state agency asking a single serious question? Prosecutors argued the answer was built into the family's structure. Homeschooling removed Erica from mandated reporter contact. North Carolina did not require welfare checks on homeschooled students. Standardized testing that should have flagged her absence was never enforced. A prior child welfare case had been closed. Social workers had visited the home twice before her disappearance and left without escalating anything. Federal charges came first. Casey Parsons was sentenced to 10 years for her role in the subsidy fraud. Sandy went to trial, was convicted of 43 counts, and was sentenced to 8 years. But the federal case was only the beginning. In 2018, days before what would have been Erica's 20th birthday, the Rowan County Sheriff's Office charged both Sandy and Casey with murder, felony child abuse, felony concealment of death, and obstruction of justice. In August 2019, Casey Parsons pleaded guilty to murder and child abuse. She was sentenced to life without the possibility of parole. 4 months later, in December, Sandy Parsons pleaded guilty to second-degree murder, child abuse, concealment of death, and obstruction of justice. His sentence was set at a minimum of 33 years and a maximum of 43 and a half. As of 2026, Casey Parsons remains at the North Carolina Correctional Institution for Women in Raleigh, where she was transferred from federal custody in November 2023. Sandy Parsons is at a state prison in Alexander County, North Carolina, with a projected release date of September 2057. Neither has succeeded in overturning any part of the state conviction on appeal. The Parsons case exposed a pattern that would repeat in other households, one where paperwork, distance, and quiet withdrawal from public institutions turned a child into someone the outside world could no longer see. Roughly 700 miles to the west, in a mobile home park in Kansas, another set of adoptive parents had already been using the same playbook for nearly a decade. Doug and Valerie Herman. Adam Herman was in elementary school the last time anyone outside his family saw him. That was the spring of 1999. He was not reported missing that year, or the year after, or the year after that. His adoptive parents told relatives he had been sent back to state custody or placed in a mental institution or something else. The story kept changing. His name stayed on paperwork long enough for the couple to keep drawing adoption subsidies for another 6 years. Nearly a decade would pass before anyone in law enforcement even opened a file. And when they did, there was no body, no crime scene, and no clear place to begin. Adam Joseph Herman had been born Irvin Groninger III in June 1987. Removed from his biological parents at a young age, he was placed with Doug and Valerie Herman and eventually adopted. The family lived at the Pine Ridge Mobile Home Park in Towanda, Kansas. Adam was pulled out of public school and homeschooled, while his adopted siblings continued to attend classes. He disappeared during the first week of May, 1999. Valerie later told investigators that the last thing she remembered was disciplining him. The Hermans never called the police. They never filed a missing persons report. When family members asked where Adam was, they were told the state had come and taken him back, or that he was in a mental hospital being treated. The story shifted depending on who was asking. The case did not surface until December 5, 2008. On that date, one of Adam's adopted siblings contacted the Kansas Department of Social and Rehabilitation Services to find out what had happened to him. The agency did not know. He had been missing, in effect, for nearly a decade, and no one in the system had noticed. The Butler County Sheriff's Office opened an investigation. What they discovered, or rather what they could not discover, would define the case for the next 15 years. Adam's body has never been found. Authorities have publicly stated that they work the case as if it were a death, but that they are not leaning one direction or the other. That legal ambiguity has kept homicide charges off the table. The Hermans were named as persons of interest, but were never charged with taking his life. What prosecutors could charge was fraud. In July 2010, Doug and Valerie were charged with felony theft for continuing to collect adoption subsidies in Adam's name long after he was gone. Records showed the couple had received roughly $52,800 in subsidies overall. In a plea agreement, they admitted to wrongfully accepting $15,488 between November 2003 and July 2005. How does a child vanish from a mobile home park in Kansas for 9 years without a single institution noticing? The same structural pattern that ran through the Parsons case ran through this one. Adam had been in protective custody for 2 days in 1996 after an abuse report, but had been returned when the report was ruled unsubstantiated. Concerns were reportedly raised with child welfare officials on at least 3 separate occasions without resulting in removal. The Harrimans had withdrawn him from a public school in Derby and begun homeschooling him around the same time he disappeared. Kansas homeschool law required almost no oversight. There were no records of homeschooled students at the state level. A state senator, Gene Schodorf, later called for an audit of how the case had been handled. The Harrimans were convicted of welfare fraud in 2011. Butler County District Judge David Ricca handed down the maximum sentence available under the state grid. Doug was sentenced to 9 months. Valerie was sentenced to 7 months. They were also ordered to pay $5,000 in fines and $15,488 in restitution. That was the extent of their criminal exposure. No homicide charge, no life sentence, no closure for a child who by then had been missing longer than he had ever been at home. The Kansas oversight gap the case exposed became a legislative talking point, but not a legislative outcome. The state's homeschool law remained largely unchanged in the years following the conviction. Butler County continued to operate the case as an open missing person investigation, and the sheriff's office continued to publicly identify the Harrimans as persons of interest without additional charges being filed. Doug Harriman died in July 2016. The couple had moved to Grove, Oklahoma. His obituary reportedly listed Adam among his survivors, even though authorities had by that point publicly stated they believed Adam was dead. As of 2026, Valerie Harriman has never been charged in connection with his disappearance. The Butler County Sheriff's Office has repeatedly debunked online rumors that Adam has resurfaced. The case remains open and officially unresolved. The parents remain the prime suspects. Where Adam Harriman's case ended in silence and no body, the following case ended with a kind of physical evidence prosecutors rarely see. Evidence that was found by accident and preserved not by investigators, but by a landlord going through a rental property after the tenants had been arrested. Michael and Heather Jones. Adrian Jones had told a caseworker 2 years before his passing that he was being harmed at home. That warning went into a file. The file stayed in the file. The adults responsible for verifying his safety would not have direct physical contact with him for almost 4 years. In late 2015, police responded to a domestic disturbance at his father's rental property in Kansas City, Kansas. During that visit, they learned Adrian was not there. His remains would be found on the property that same day. Adrian, known to his family as AJ, lived with his father Michael Jones, a former bail bondsman, and his stepmother Heather Jones. His maternal grandmother, Judy Conway, has spoken publicly about him in the years since. Prosecutors described him as a curious, energetic child. The Jones household was a blended family with multiple children and a pattern of moving repeatedly between Missouri and Kansas. Prosecutors in later reporting concluded that this movement was not random. Each time a child welfare agency in one state began to build a case, the family relocated across the state line. Investigations were dropped, files were closed, and the process began again in a new jurisdiction. Adrian's harm was documented in retrospect in the couple's own devices. While they awaited trial, their landlord discovered photographs and videos on a computer left behind at the property. The material, in the words of the district attorney, meticulously cataloged what had been done to him. Adrian's passing occurred in September or October 2015. The medical examiner concluded that his death was the result of prolonged deprivation of food. In the weeks beforehand, he had been kept isolated from the rest of the household. When police searched the property, they found his remains outdoors on the grounds. District Attorney Jerome Gorman declined to confirm widely circulated claims about what had been done with those remains. but he described the scene as one of the worst investigators in his office had ever encountered. Both Michael and Heather Jones were charged with first-degree murder and multiple counts of child abuse. Neither case went to trial. In November 2016, Heather Jones pleaded guilty to first-degree murder and 2 counts of child abuse. She was sentenced to life in prison with no possibility of parole for 25 years, plus an additional 5 years and 8 months for the abuse counts. 4 months later, in March 2017, Michael Jones pleaded guilty to first-degree murder. He was sentenced in May of that year to life with no possibility of parole for 25 years. How does a child who is on the radar of a state social services agency, who has spoken directly to a caseworker about being harmed, remain in the household where the harm is happening? The answer, according to internal records later released by the Missouri Department of Social Services, is that the agency's last confirmed physical contact with Adrian occurred almost 4 years before his passing. More than 2,000 pages of records were released to NBC News in 2017. They painted a picture of a case that had been technically active but functionally invisible. Warnings had been noted. Follow-ups had not been completed. Jurisdiction had shifted every time the family moved. The plea agreements ended what could have been a lengthy trial and closed both criminal cases without a public airing of what the recovered photographs and videos contained. Under Kansas law, the guilty pleas to first-degree murder carried automatic life sentences with the mandatory minimum service period attached. Neither defendant offered mitigation testimony during sentencing. Neither offered a public account of what had happened inside the household during the months leading up to Adrian's passing. The recovered digital material remained sealed under court order and was described only in general terms by the prosecution. The state of Kansas eventually approved a $1 million settlement of the wrongful death lawsuit filed by Adrian's family. Governor Laura Kelly and legislative leaders authorized the payment on March 12, 2024. A separate suit filed in Missouri had settled earlier, in 2020, for an undisclosed amount. In 2021, Kansas passed what became known as Adrian's Law. The statute created a legislative child welfare oversight committee and required officers and caseworkers responding to abuse allegations to visually observe the child in question, not simply speak to the adults in the home. The law also addressed information sharing across state lines when a family known to a child welfare agency in one state relocated to another. As of 2026, both Michael and Heather Jones remain incarcerated in Kansas. Neither will be eligible for parole until they have served the mandatory 25-year minimum on their first-degree murder convictions. There have been no successful appeals to reduce or reopen either sentence. The Jones case revealed how a family in motion could stay a step ahead of the systems built to notice a child in danger. The following case reveals a very different mechanism, a household that stayed in one place, that presented itself publicly as devoted foster parents, and that used the machinery of media sympathy to bury the truth for weeks. Liz and David Carroll. On August 22, 2006, Liz Carroll stood in front of television cameras and told the public that her foster son, Marcus Feasel, had gone missing at a park in the Cincinnati area. She said she had blacked out from low blood pressure while at the park with him. When she came to, he was gone. Within 24 hours, nearly 3,000 volunteers were combing parks, ditches, and wooded areas across 2 counties, searching for a small child with autism. Marcus was not in any of those places, and the person who would eventually tell prosecutors what had actually happened was living in the same house as the Carrolls. Marcus Feasel had been born in June 2003. He was a small child with autism, placed by his mother, Donna Trevino, into the Ohio foster care system. He was eventually placed with Liz and David Carroll of Union Township in Claremont County through an agency called Lifeway for Youth. What Lifeway did not know was that a third adult, Amy Baker, David's live-in partner, was living in the home. The agency also did not know that David had a disqualifying mental health issue in his background that should have prevented him from being approved as a foster parent. On August 4th, 2006, before leaving for a family reunion in Kentucky, the Carrolls confined Marcus inside a closet at the home. They left the house. According to the Claremont County Prosecutor's Office, the conditions inside that closet were not survivable during the couple's extended absence. When the Carrolls returned more than 30 hours later, Marcus had already lost his life. David Carroll and Amy Baker then transported his remains to a location in Brown County, Ohio, and disposed of them. On August 22nd, more than 2 weeks after his passing, Liz Carroll delivered the story about the park to reporters. The case began to unravel roughly 2 weeks after that. Amy Baker walked into the Claremont County Prosecutor's Office and, in exchange for immunity, told the truth. She described the trip to Kentucky, the absence from the home, and the disposal of the remains. How does a household stage a public search, appear on the evening news, and organize thousands of volunteers around a fiction? The mechanism was performance. The Carrolls behaved publicly and consistently the way grieving foster parents were expected to behave. They spoke to media. They participated in searches. They allowed cameras into their home. Every visible action pointed toward a child who had walked away from a park. The truth was locked inside a house that no one had reason to search. Liz Carroll went to trial in February 2007. On February 21st, a jury convicted her of murder, involuntary manslaughter, kidnapping, felonious assault, and endangering children. In Hamilton County, she entered no contest pleas to perjury, inducing panic and false alarms for her fabricated statements to police and to volunteer searchers. She was sentenced to 54 years to life. Her earliest possible parole eligibility falls around the year 2060. The prosecution's central witness was Amy Baker, testifying under her Ohio immunity agreement. Baker's account described the conditions inside the home before the trip to Kentucky, the confinement inside the closet, the return to the house, and the transportation of the remains afterward. The defense strategy was to portray Baker as an unreliable witness with an obvious cooperation incentive. The jury did not accept that framing. Baker's account, cross-referenced with physical evidence recovered from the home and from Brown County, was treated as the spine of the case. David Carroll, faced with the same evidence and Amy Baker's cooperation, pleaded guilty in February 2007 to murder and gross abuse of a corpse. He was sentenced to 15 years to life on the murder count, with an additional year attached for the abuse of corpse charge. In September 2022, David Carroll had his first parole hearing. The parole board denied release. The board's stated reasoning included the finding that he lacked insight into what the board described as his criminal thinking errors. Community opposition was substantial. His next scheduled hearing is in May 2032. Amy Baker's Ohio charges were formally dropped in exchange for her cooperation. She later faced a related charge in Kentucky, which was also resolved without conviction. The state of Ohio revoked Lifeway for Youth's license in 2007. The revocation was upheld on appeal. David Carroll's June 2006 domestic violence arrest, which the agency was required to report and did not, was a key factor in the license revocation. The case became a driver for reforms in how Ohio vetted foster placements. As of 2026, Liz Carroll remains incarcerated with no parole eligibility for more than 3 decades. David Carroll remains incarcerated in the Ohio prison system, denied parole in 2022, with his next hearing set for 2032. The Feasel case ended because a witness came forward. The final case in this half of the list had no such witness. It had a father, a girlfriend who died before she could ever be questioned, and a child whose remains have never been recovered. Aaron Thompson and Shelley Lowe. On November 14, 2005, Aaron Thompson walked into an Aurora, Colorado police station and reported that his daughter, Aron, had run away from home. He said she had left the house after being denied a cookie. Within 3 days, Aurora detectives had reached a very different conclusion. Based on a tip from someone close to the household, they believed Aroni had not been alive for as long as 18 months. The other children still living in the home were already beginning to describe years of harm. And Aroni's biological mother, who lived in Detroit, had not been allowed to speak to her daughter in years. Aroni Thompson had been born in Michigan. Her biological mother, Lynette, had lost contact with her after Aaron moved the children to Colorado in 2001 and cut off communication. She lived on East Kepner Place in Aurora with her father, his girlfriend Shelley Lowe, and a large extended household. That household included Lowe's own children, Lowe's teenage brother Rajon Russell, and Aron's brother Aaron Jr. Lowe was pregnant at the time Aron was reported missing. The report itself was unusual in one specific way. Thompson cooperated with investigators in ways guilty parties typically do not. He allowed searches of the property. He provided DNA samples. He agreed to take a polygraph. On the surface, he was a father whose child had run away. But when Aurora detectives began interviewing the other children in the home, the picture changed. The children described years of physical harm inside the household. They described conditions that had gone on for a long time. They described Aron's passing as having occurred not on November 14, 2005, but potentially as far back as May of 2002. Prosecutors would later place the window of her passing somewhere between May 2002 and November 2005. That is a window more than 3 years wide. Court records referenced accounts that Arone may have been buried in a field. Investigators searched extensively. Her remains have never been recovered. The exact cause of her passing has never been definitively established. Shelley Lowe was implicated in the case. She died before she could be charged. In 2006, she died suddenly of heart disease. She was never formally interviewed by investigators about what happened to Aron. Her death removed a key potential witness and a key potential defendant from the case in a single stroke. How does a father report his daughter missing and in the same conversation walk directly into an investigation that concludes she has been gone for years? The other children in the home were the answer. They had been living with the truth. Once investigators separated them from the household and began speaking to them individually, they described a home in which what had happened to Aroni had been part of a longer pattern, and in which she had disappeared, in their accounts, sometime before the runaway story was ever told to police. A grand jury returned a 60-count indictment against Aaron Thompson in 2007. The counts included child abuse resulting in death and a range of related charges. He went to trial in 2009. On September 28, 2009, a jury convicted him of 31 of the 55 counts submitted for verdict, including the top count of child abuse resulting in death. He was sentenced to 114 years in prison. Thompson appealed. His appeals included a Sixth Amendment argument based on his claim that he had been denied his choice of counsel during trial. The Colorado Court of Appeals rejected that argument and affirmed the conviction. Subsequent post-conviction efforts have not resulted in his release. The Aurora Police Department has kept the case open in the cold case sense that Aaroni's remains have never been recovered. Investigators have publicly said that the accounts provided by the surviving children, together with the physical evidence collected from the home, supported the conviction Thompson received. What those accounts have not been able to do is direct investigators to where Aaroni was buried. The search for her remains has continued intermittently over the years without a positive result. The systemic gap in Aaroni's case was different from the ones in Kansas and North Carolina. There was no homeschool paperwork, no adoption subsidy, no formal cover of a home education program. What there was instead was a household in which multiple children had been signaling for years, and where the pattern of those signals had not resulted in any intervention capable of removing anyone. Once the case broke, the surviving children provided the record. The record was consistent. It was also, by then, several years too late for Aaroni. As of 2026, Aaron Thompson remains incarcerated in the Colorado Department of Corrections, serving his 114-year sentence. Shelley Lowe died before facing any criminal proceeding. Aaroni's remains have never been recovered. Her biological mother in Detroit has never been able to bury her, and the case remains listed among Colorado's cold case files. Not subscribed yet? Now's the time. And if audio's more your thing, find us on Spotify too. You can click the link in our bio. Kimberly Traynor and Royce Ziegler. On October 29, 2007, a fisherman in Galveston Bay pulled a blue plastic storage container out of the water. Inside was a small child. Nobody in Texas knew who she was. Investigators released a composite sketch to the public and gave her a temporary name, Baby Grace. It would be a full month before that sketch reached a grandmother in Ohio who thought she recognized the face. And it would be a few days more before DNA confirmed what she already suspected. The container held her granddaughter, Riley Ann Sawyers. The people who had put her there were the child's mother and stepfather. Riley Ann Sawyers had been born in Mentor, Ohio, in March 2005. Her mother, Kimberly Dawn Traynor, had been very young when she became pregnant. Her father was Robert Sawyers. For the first years of Riley's life, she was primarily cared for by her paternal grandmother, Cheryl Sawyers, in Ohio. Cheryl had a custody interest and had been the stable adult in Riley's early life. That arrangement ended when Kimberly met Royce Clyde Ziegler II online, through the video game World of Warcraft. In May 2007, Kimberly moved from Ohio to Spring, Texas, to live with him. They married on June 1, 2007. Cheryl Sawyers was left in Ohio, and Riley was taken to Texas. Riley lost her life on July 24, 2007. The couple did not report her passing. They hid her remains in a storage shed for 1 to 2 months. They then placed her in a plastic container and drove to Galveston Bay, where they dropped the container into the water. The child would remain unidentified for a full month. While Riley's remains were sitting in the bay, life in the Ziegler household continued as if she still existed on paper. Cheryl Sawyers from Ohio requested a welfare check through Harris County authorities. A deputy came to the home. The couple presented him with a forged letter, made to look as though it came from Ohio Child Protective Services, explaining Riley's absence. The deputy left. The welfare check was closed. On October 29th, the fisherman found the container. The medical examiner determined that Riley had suffered fatal head injuries. On November 30th, 2007, DNA confirmed her identity. Cheryl Sawyers' tip had matched. How does a young couple move a child across the country, take her life within weeks of that move, and then run a full month of ordinary life, while her remains sit in a storage shed just outside the house? Distance and paperwork worked together to buy the couple time. Riley's family in Ohio had no legal standing to enter the Texas home. The deputy who came for the welfare check had no reason to disbelieve a document that looked official. The couple's neighbors in Spring, Texas, had never known Riley. She had been in the state for a matter of weeks. Her absence, in that small window, could be explained away in a single conversation. Both were indicted for capital murder and for tampering with evidence. Kimberly Trenner's trial came first. On February 2, 2009, a Harris County jury convicted her of capital murder. Because the prosecution did not seek the death penalty, citing an inability to prove future dangerousness under Texas law, her sentence was automatic: life without the possibility of parole. Royce Ziegler's trial followed. On November 6, 2009, a jury convicted him of capital murder as well. He received the same automatic sentence: life without the possibility of parole. Each defendant blamed the other. Neither escaped conviction. The prosecution's decision not to seek the death penalty against either defendant drew comment at the time. Under Texas law, a capital murder conviction where the state does not seek death carries an automatic life without parole sentence, with no jury discretion on the length of the term. The Harris County District Attorney's Office publicly explained that it did not believe the evidence would support the future dangerousness finding Texas law requires for a death sentence. Neither defendant had a prior violent record, and the state concluded a life without parole disposition was the correct outcome. Cheryl Sawyers, the paternal grandmother who had raised Riley in Ohio for the first years of her life, was the person who requested the initial welfare check the Zieglers defeated with a forged letter. She was also the person who saw the composite sketch on a news broadcast and contacted authorities. Without her identification, the container recovered from Galveston Bay might have remained an unidentified child for years. Riley Ann Sawyers was returned to Ohio for burial. As of 2026, both Kimberly Trenor and Royce Ziegler remain incarcerated in the Texas Department of Criminal Justice, serving life without parole sentences. Neither is eligible for parole under Texas law. Riley Ann Sawyers is buried in Ohio, near her paternal grandmother, who identified her from a composite sketch on a news broadcast. The Baby Grace case broke because a grandmother in another state kept watching the news. The following case broke for a different reason. It broke because a hospital and a coroner in Washington state picked up a phone and called Child Protective Services, and because the surviving children in the home had, at that point, no reason left to keep the secret. Larry and Carrie Williams. On the evening of May 12, 2011, an ambulance was called to a rural property in Sedro-Woolley, Washington. The temperature outside was around 40 degrees Fahrenheit. In the backyard, a young girl had been found unresponsive on the ground. Her name was Hannah Williams. She had been adopted from Ethiopia 3 years earlier. When the hospital and the coroner examined her, they did what nobody had done in the years the Williamses had been fostering and adopting children. They picked up the phone and called Child Protective Services. Hannah Grace Rose Williams had been born Hannah Alemu in June 1997. Adopted from Ethiopia in 2008 through Adoption Advocates International. She had previously lived at the Kidan Merit Children's Home in Addis Ababa. She was placed with Larry and Carrie Williams of Sedro-Woolley, Washington, along with a younger adopted brother from Ethiopia, Emmanuel. The Williams family had 7 biological children. With Hannah and Emmanuel, the household grew to 9. They presented as a devout, large homeschooling family in a rural Washington town. Neighbors saw a stable, faith-based, self-sufficient home. Nobody outside the immediate household had any regular contact with the two adopted children. Hannah's passing on May 12, 2011, was ruled hypothermia by the medical examiner, with malnutrition listed as a contributing factor. The autopsy documented significant weight loss over the year leading up to her passing. According to Skagit County Prosecutor Rich Wyrick, she had lost a significant portion of her body weight during that period. Carrie Williams later testified that she had not noticed the change. When Child Protective Services arrived and separated the surviving children from the household, Emmanuel began to describe conditions the outside world had not seen. He described a household in which Hannah had been made to sleep away from the family, made to use an outdoor toilet, and made to stay outside as a form of punishment. His statements would form the core of the prosecution's case, both for the homicide charge involving Hannah and for the assault charge involving him. Both Larry and Carrie Williams were arrested and charged with homicide by abuse and first-degree assault of a child, the assault count relating to Emmanuel. The trial lasted 7 weeks. On September 9, 2013, the jury returned its verdict. Carrie Williams was convicted of homicide by abuse, first-degree manslaughter, and first-degree assault of a child. Larry Williams was convicted of first-degree manslaughter and first-degree assault of a child. On the homicide by abuse count against Larry, the court declared a mistrial when the jury could not reach unanimity. Hannah's age mattered in a way that few people outside a courtroom would ever consider. The homicide by abuse statute in Washington required the victim to be under 16. Ethiopia had no birth records for Hannah that anyone could produce, and tooth and bone tests conducted for the trial produced conflicting estimates. The court proceeded on the finding that she fell within the statutory age range required for the homicide by abuse count at the time of her passing. How does a household with 9 children in a small Washington town avoid contact with Child Protective Services for years, only to generate a mandatory call to the agency the day a child stops breathing in the backyard? Homeschooling was the structural piece. The Williamses homeschooled all 9 children. The 2 adopted children had almost no independent contact with adults outside the household. There were no teachers, no coaches, no medical checkups that involved the children being seen alone. Nobody outside the family had any reason to notice what was happening inside it. Sentencing came on October 29, 2013. Skagit County Superior Court Judge Susan Cook was on the bench. Carrie Williams was sentenced to just under 37 years, at the top of the standard range. Judge Cook stated on the record that she believed the defendant probably deserved more time than the statutory range allowed. Larry Williams was sentenced to nearly 28 years. Carrie's first-degree manslaughter count was later vacated as duplicative of the homicide by abuse count. The Williamses appealed. Their direct appeal was denied in 2015. Subsequent post-conviction petitions, including ineffective assistance of counsel arguments, have also been denied. Larry Williams's mistrial on the homicide by abuse count was not retried by Skagit County prosecutors, who cited the manslaughter conviction as an adequate outcome given the sentence attached to it. Neither Williams has secured any reduction in their term through the appellate process to date. As of 2026, Larry Williams remains incarcerated at the Coyote Ridge Correction Center in Connell, Washington. Carrie Williams remains at the Washington Correction Center for Women in Gig Harbor. The Williams case became a touchstone in ongoing conversations about international adoption oversight and about homeschooling as a factor in child welfare visibility. No agency had contact with the adopted children in the household before Hannah's passing. The Williams case surfaced because a coroner made a phone call. The following case surfaced because a Florida Department of Children and Families hotline received a tip. and because a father was pulled over on the shoulder of Interstate 95 with a truck that told a story he could not. Jorge and Carmen Barahona. On Valentine's Day, 2011, police officers approached a pickup truck parked on the shoulder of Interstate 95 in West Palm Beach, Florida. Inside the cab was a man named Jorge Barahona, along with his young son Victor, who was showing signs of chemical exposure. In the bed of the truck, wrapped in plastic bags and doused in industrial pesticide, was the body of Victor's twin sister, Nubia. The truck had been located because someone had called a Department of Children and Families hotline 3 days earlier, worried about the twins. 15 years later, Nubia's case would still not be closed. Her adoptive father would still be awaiting trial. Nubia, Dr. Barahona, and her twin brother Victor had been fostered by Jorge and Carmen Barahona starting in 2004 and adopted by them in 2009. They lived in West Miami-Dade, Florida. Nubia had been in the state child welfare system since she was very young. Jorge worked in pest control and electrical work. Carmen had been the primary parent figure at home. Detectives determined that Nubia had lost her life on February 11th, 2011, 3 days before her body was found in her father's truck. The manner of death was ruled homicide by beating. Concealment had begun almost immediately. Her body had been wrapped in plastic and doused in chemicals. Jorge had been transporting it in a plainly marked pest control truck along the interstate. Victor, still alive in the cab of the truck, was in serious medical distress from exposure to the chemicals in the bed of the truck. He would survive. Jorge was charged separately in Palm Beach County with the attempted taking of Victor's life. Both Jorge and Carmen Barahona were indicted by a Miami-Dade grand jury in March 2011. The indictment contained 18 counts, including first-degree murder, multiple counts of aggravated child abuse, aggravated child neglect, and, for Jorge, the mutilation of a body. Prosecutors announced they would seek the death penalty. The case would take more than a decade to resolve on one side and remains unresolved on the other. On February 21st, 2020, Carmen Barahona pleaded guilty to first-degree murder and aggravated child abuse. In exchange for a life sentence and an agreement to testify against Jorge, she was removed from consideration for the death penalty. Her life sentence is deferred and will be formally imposed once her cooperation in the case against Jorge is complete. Jorge's case has been repeatedly delayed by competency litigation. Florida law requires a defendant to be mentally competent to stand trial. In March 2024, a judge found Jorge Barahona incompetent. In July 2025, after a 2-day hearing before Miami-Dade Circuit Judge Andrea Ricker-Wolfson, he was found competent again. As of late 2025, the trial had not yet occurred. Judge Wolfson had publicly stated she wanted a trial in October or November of that year. How does a case involving the passing of a young child, evidence recovered from a truck on a highway, and a suspect apprehended at the scene remain unresolved 15 years later? Two mechanisms have combined to stall the case. Competency litigation in a death penalty case can extend for years, particularly when both sides are entitled to their own experts. And a co-defendant's plea agreement structured around future cooperation freezes both cases in a kind of holding pattern. Carmen's life sentence cannot be formally imposed until she testifies. Jorge cannot be tried until he is stably competent. The two cases wait on each other. As of 2026, Jorge Barahona has been found competent and is awaiting trial on first-degree murder and related counts, and continues to face the possibility of the death penalty. Carmen Barahona is committed to her agreed life sentence. pending completion of her cooperation. Nubia's case is one of 2 on this list that remain legally open in the strict sense, with a co-defendant still to be tried. The Nubia Barahona case became one of the most significant child welfare failures in Florida's modern history. Warning signs from school officials and medical professionals dating back to 2008 had been logged but not acted on. Hotline reports had been received and closed. A caseworker had been to the home. An independent report, later known as the Nubia Report, criticized inadequate case management and poor information sharing between agencies. The report also documented that at least 1 prior in-home visit had produced no follow-up despite what the reviewers described as clear indicators of concern. Following the case, the Florida Department of Children and Families added roughly 100 child protection investigators, along with enhanced training and reduced caseloads, according to the department's own statements. The Barahona case ended on the state's side, with a life sentence still waiting to be formally imposed and a trial still waiting to begin. The following case ended in a mobile home park in Gary, Indiana, when a young woman finally told her mother what had happened to her brother and led investigators to a shed with a concrete slab underneath. Riley Choate and Kimberly Kubina. For years, family members and neighbors around a mobile home park in Gary, Indiana, had been told the same story about Christian Choate. He had run away. He had gone to live somewhere else. He was no longer part of the household. What none of them knew was that Christian had never left the property. In May 2011, his older sister told her mother what she had been carrying, and that mother went to the police. Investigators arrived at the property with a warrant and began looking for a concrete slab. Christian Milton Choate had been born in December 1995. He was the son of Riley Choate and Amy Eriks. Amy had left Riley, citing his behavior. Riley later gained custody of Christian and his sister Christina. The family lived in the Black Oak section of Gary, Indiana, in a mobile home park. In 1999, Riley married Kimberly Kubina in Christian County, Kentucky. At times, as many as 10 children lived in the trailer. Christian's situation inside that household became increasingly isolated over the years. Between 2007 and his passing, according to court records, he was confined first to a basement room and eventually to conditions that were the centerpiece of the prosecution's later case. Christian lost his life on April 4, 2009. His remains were not discovered until May 2011, 2 full years later. The concealment was physical. Kimberly Kubina purchased concrete and lime. She and Riley buried Christian's body under a shed at the mobile home park. They placed a cross and a Bible on the ground above him. Then they told relatives and neighbors he had run away and moved the family to Kentucky. The case broke because Christina, referred to in court records as CC, eventually told her mother, Amy Eriks, what had happened. Amy contacted the police. Investigators returned to the Gary property, located the shed, and dug beneath it. Both Riley Choate and Kimberly Kubina were charged with 13 counts. The counts included murder, neglect of a dependent, battery, criminal confinement, and obstruction of justice for moving the body. Neither case went to trial. Kimberly Kubina pleaded guilty first, in May 2012, to neglect of a dependent. She agreed to testify against Riley. On February 19, 2013, she was sentenced to 35 years in the Indiana Department of Correction. Her sentence was affirmed on appeal that same year. Riley Choate pleaded guilty in December 2012. He entered a plea to Class A felony neglect of a dependent causing death, moving a body, and depriving his daughter of an education. He also admitted to habitual offender status under Indiana law. In January 2013, he was sentenced to 80 years. Court records indicate the plea was structured to avoid a potentially longer sentence, up to 120 years, that a jury conviction might have produced. How does a young person spend the final years of his life inside a mobile home, with no school records, no medical records, and no visible presence in the community, without a single agency intervening? The Indiana Department of Child Services had investigated the family multiple times over the years. Reports had come from schools, from relatives, and from anonymous callers. Each investigation had been closed after either an in-home visit or a phone check. In none of those closures did the record show a supervisor requesting that Christian be seen and interviewed alone by a caseworker. Christian's confinement, according to later reporting, was designed in part to prevent him from making it out of the house to describe what was happening. He had written letters describing his situation. Those letters were later recovered and became part of the trial record. Kubina appealed her 35-year sentence, arguing that the term was disproportionate, given her plea agreement and her cooperation against Riley. The Indiana Court of Appeals rejected that argument in 2013. Riley Choate filed a post-conviction relief petition, raising ineffective assistance of counsel arguments. That petition was denied. Neither the length of Riley's 80-year term nor the structure of Kubina's plea have been reopened by any subsequent state or federal filing. As of 2026, Riley Choate is incarcerated in the Indiana Department of Correction, serving 80 years. His post-conviction relief petition was denied. Public records indicate his release date is January 23, 2064. Kimberly Kubina's Indiana Department of Correction projected release date was reported as April 30, 2025. Current IDOC records should be consulted to confirm her present custody status. Her 35-year sentence was upheld on appeal. The systemic issues in the case have been publicly acknowledged. Multiple abuse and neglect reports had been received by the state and had not resulted in removal. The paperwork existed. The intervention did not. The Choate case closed with a young person whose family had convinced an entire community that he had walked away from home. The final case in this list ended in a culvert near a Texas suburb, with a father who told police 3 different stories in 3 weeks about what had happened to his daughter. Wesley and Sinai Matthews. On October 7, 2017, Wesley Matthews called the Richardson, Texas Police Department to report that his adopted daughter, Sharon, was missing. He said he had put her outside the family home around 3 in the morning as punishment for not drinking her milk. He said that when he checked on her later, she was gone. He also said he had waited about 5 hours before calling police. An Amber Alert went out. A community search began. Wesley suggested to investigators that coyotes may have taken her. What followed was 15 days of searching, 3 separate versions of the story from Wesley, and a discovery in a culvert less than a mile from the family home. Sharon Matthews had been born in India. She was adopted in the summer of 2016 from an orphanage in Nalanda, in the state of Bihar. Her biological parents had left her in Gaya. She was adopted by Wesley and Sinai Matthews of Richardson, Texas. Wesley was an engineer originally from Kerala. Sinai was a nurse. They also had a biological daughter, born in December 2013. To the outside world, they were an ordinary suburban professional family. Wesley's initial story, on October 7th, was that Sharon had wandered off after being placed outside at 3 in the morning. That story anchored the initial search. 15 days later, on October 22nd, 2017, Sharon's body was found in a culvert not far from the family home. The remains had been placed in a plastic bag. Wesley's story then changed. He told investigators that Sharon had choked on milk while he was feeding her, and that he had panicked and moved her body himself. The Dallas County District Attorney's Office would later describe the effort to steer investigators away from the culvert as a wild goose chase. The Dallas County Medical Examiner ruled the manner of Sharon's passing homicide. Specifically, the office described it as homicidal violence. The exact cause could not be determined because of the state of the remains. This distinction, homicide as manner, cause undetermined, would matter at trial and in subsequent appellate review. What emerged during the punishment phase of the case, however, was a longer record. Dr. Suzanne Dackil, a child abuse pediatrician, testified that she had reported Sharon to Child Protective Services in March 2017 after examining her and finding multiple fractures. Records documented 5 fractures over roughly a 5-month window. The physician concluded that the injuries were intentional and had occurred after the adoption. CPS had investigated after Dr. Dackil's referral. Sharon had been briefly removed from the home and then returned. The investigation had been closed with the Matthews cleared. How does a young child who has been referred to Child Protective Services by a pediatrician, briefly removed from the home, and then returned, lose her life inside that same home only months later, without a further intervention? The March 2017 investigation had been closed, and no continuing case had followed her back to the household. When Sharon's remains were found in October, that closed file became the centerpiece of the systemic failure analysis Texas child welfare officials would later be pressed to explain. Wesley Matthews was originally charged with capital murder. Sinai Matthews was charged with child endangerment for allegedly leaving Sharon home alone while the rest of the family went out to dinner on October 6th. On March 1st, 2019, the child endangerment charge against Sinai was dismissed for insufficient evidence without prejudice, and she was released. Wesley's case went forward. On June 24th, 2019, the day capital murder trial was scheduled to begin. He pleaded guilty to the lesser charge of injury to a child by omission. The plea preserved the possibility of a punishment phase trial. On June 26, 2019, a Dallas County jury, in a proceeding presided over by Judge Amber Givens Davis, returned a sentence of life in prison. His motion for a new trial was denied that September. Wesley entered the Texas Department of Criminal Justice on July 25, 2019. On December 14, 2020, the Texas Fifth Court of Appeals affirmed his conviction and life sentence, overruling all 6 of the issues he had raised on appeal, including an Eighth Amendment challenge to the sentence. As of 2026, Wesley Matthews remains incarcerated in the Texas Department of Criminal Justice, serving a life sentence. He is not eligible for parole consideration until October 17, 2047. Sinai Matthews was not convicted of any charge related to Sharon. In January 2018, the couple's parental rights to their biological daughter were voluntarily terminated. India revoked the couple's overseas citizen of India status. India also suspended the adoption agency and revised its international adoption processes in the wake of the case. Cases like these show how easily a child can be hidden in plain sight when the systems built to protect them fall short. Thanks for watching. Click here to see our next video.